Good afternoon. Good afternoon and welcome to the Buncombe County Board of Adjustment regular May meeting. Welcome to members of the public and those viewing online. We'll start with call to order and welcome, then we'll go to announcements from staff. Any announcements from staff today? Yeah. Mr. Pennington.
Good afternoon, everyone. I'm Nathan Pennington. I'm the planning director for the county. I just wanted to let you all know about a nationwide scam that's occurring. When you pay your application fee for whatever you're presenting to the Board of Adjustment, you've paid your fee. Now, what's happening is nefarious groups are scraping public data. We have a development project page where we put information about an application project so that everyone can see it in full transparency. So what they're doing is they're taking Buncombe County symbols, using my name, bogus email addresses, and they're instructing people, here's the dead giveaway. We will never ask you to wire money. We will never ask you to pay in cryptocurrency, and we will never ask you to pay in gift cards. So please, if it looks suspicious, please call us. We are doing everything on our end to do banner ads. We are going to start redacting some of the personal data, and also check the email addresses. We are buncombenc.gov. If you see .usa or something suspicious like that, it's a scam, okay? Do you all have any questions about this? This has actually been reported in the American Planning Association. It's happening all across the country, and as we all know, with AI, the scams are getting more and more elaborate. So, thank you for your time.
Thank you, Nate. We'll move to a roll call of board members.
Joel Mazelis.
Paul Wilczynski.
Greg Allen.
Andy Ball,
Greg Phillips.
Gabe Quisenberry.
Mark Diaz.
and then staff.
Dana Alley. Savannah Glantz.
Amy Broughton.
Verona Sauter.
Thank you so much. We'll move to approval of meeting minutes. We have meeting minutes by email to the board from the last meeting, which was the 8th of April. Any questions, comments, edits to that, or a motion regarding the minutes?
Move to accept the minutes.
There's a motion to approve. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you. Moving to disclosure of ex parte communications or conflicts of interest. Any member of any board exercising quasi-judicial functions pursuant to NC General statutes shall not participate in or vote on any quasi-judicial matter in a manner that would violate any person's constitutional rights to an impartial decision-maker. Impermissible violations of due process include, but are not limited to, a member having a fixed opinion prior to the hearing that is not susceptible to change, an undisclosed ex parte communication, a close familial, business relationship, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. And we'll start with Mr. Mazzels.
No.
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 No. No.
Thank you very much. Moving to Section F, public hearings. This is a quasi-judicial evidentiary hearing on the record. And that means that similar to a court hearing, state and local law set specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision based on the competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts and standards, not personal preference or opinion. Matters of personal knowledge and specific facts are acceptable. Opinion, however, speculation on traffic, impact on the community, crime, etc., is not. We do value a transparent process and encourage the community to remain engaged and participate, but given this is a hearing on the record, there are certain topics and areas that limit the type of testimony we can receive from members of the public without standing. And if you, as a reminder, if the audience will please silence their cell phones, make sure those don't go off in the middle of the hearing. And I'm doing the same. All right. Moving to public hearings, with the board's consent, we'll move forward to hear ZPH 2026 00012 MHO Crescent Place Apartment Special Use Permit because they have a funding deadline they have to apply for in the next this month, actually. If they don't do that, then they can't be eligible for this year's funding. So we'll start there and then move to Carroll after that. So we will start with Vanna Alley.
Please state your name and raise your right hand.
Dana Alley?
Do you swear to tell the whole truth at this hearing?
Yes.
Please continue.
I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. Ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, so tendered.
This is the review of ZPH 2026-00012 Crescent Place Apartments. Applicant is Justin Thorne of Civil Design Concepts. Project is located at an unaddressed parcel on Crescent Hill Drive, and the total acreage is 4.38. It is serviced by public water and sewer. Property is zoned R2 with no overlays present. This is for the development of 60 affordable units at 100% affordability. Applicants are utilizing community-oriented development to increase density on this parcel. A deviation to maximum building height is being requested from 35 to 43 feet. If approved by the board, staff recommends the following conditions of approval, which I will summarize. Project must be constructed as depicted in site plan. Prior to commencement of land disturbance and construction, the applicant shall submit a site plan review permit for the entire project. Applicant must agree in writing to these conditions prior to commencement of site work.
We'll open up for board questions for staff on this application. Anything the board has? Thank you so much. Yeah. Is there anyone here wishing to assert standing in this matter? Any standing requests from the audience? There'll be time for witness testimony later on in the hearing. Going twice, going three times. Thank you. We'll introduce the applicant's representative.
Good afternoon, Mr. Chairman. My name is John Knorr. I'm an attorney with the Robertson Stevens Law Firm, and I'm excited to present this project on behalf of Mountain Housing Opportunities and Lutheran Services for the Aging. We know you have a full agenda today, so we will try and be brief, but if you have any questions, please don't hesitate to ask me or the witnesses. Unless there's any initial questions, we'll go ahead and get started with our representative from Mountain Housing Opportunities.
Thank you.
Oh, please state your name and raise your right hand.
Rich Olenichek?
Do you swear to tell the truth at this hearing?
Yes.
Okay, please continue.
Good afternoon. I'm Rich Olenichek. I'm the Director of Community Rental Investments at Mountain Housing Opportunities. MHO has been working on affordable housing for over 37 years. We have home repair, home ownership, rental developments. I've been with them for 20 years now. For this development, we want to do a partnership with Lutheran Services, who you'll hear in just a second. We planned a 60-unit senior development there at Crescent Place. There'll be 1- and 2-bedroom apartments. Since it's 100% affordable, we'll be serving a range of AMIs. We're going to try to hit 30% AMI, 50, 60, and 80. We have a lot of planned amenities for the development, including a community room, exercise room, computer center, playground, gazebo or picnic pavilion, and then a small dog park too. So that's it in a thumbnail. So I'll open it up for any questions you guys have that I might be able to answer.
We'll open for board questions. Can you walk us through the parking allocation, or do you have a witness? Do you have an
We
engineer?
do. Warren Suggs here, and we'll go through the details of the project. Really, Rich is just going to introduce it, and he did it so well I didn't even have to ask questions. So,
Great. Do you have a split in terms of the 1-bedroom, 2-bedroom
Yes.
unit counts?
There's going to be 36 ones and 24 twos.
Great. Perfect. And when might you start collecting applications for this if timing goes as you plan? Put that way.
let's see, if timing goes well, it'll close sometime next year. Probably take 12 to 14 months to construct, so it could be 2028,
Yeah.
to tell you the truth.
Nice. All right, any board questions from HO? Thank you, sir, very much.
Thank you.
Okay, thank you, Rich. Our next witness is Stephanie Heron Honeycutt.
Raise your right hand and state your name.
Stephanie Heron Honeycutt.
Do you swear to tell the truth at this hearing?
I do.
Okay, please continue.
Stephanie, just a couple quick questions.
Sure.
One, can you tell the board your relationship with Lutheran Services, please?
Sure. I'm the Vice President of Strategy for Lutheran Services for the Aging.
Okay. And tell us a little bit about the partnership between MHO and Lutheran Services of the Aging.
So we own Trinity View, which is an independent living facility next door to this property that we own. And again, our mission is to serve seniors. We're doing that in that capacity, so we wanted to also to be able to offer seniors that may have financial constraints an opportunity to live in Buncombe County with this subsidized housing. So when we started the discussion with Mountain Housing Opportunity, their vision, their mission seemed to align with ours. So we chose to proceed with the relationship with Mountain Housing Opportunity.
And Stephanie, you had indicated that y'all have an existing facility for senior citizens. Is that, when we look at the map, and we'll go in those details with Warren, is that the facility immediately to the north of the proposed development site?
It is.
And roughly how many people are you servicing there?
So we have 78 independent living, and we have 20 assisted living residents there, so 104.
Great. And how long has that facility been open?
Oh, I'm going to tell you off the top of my head, 1991.
Great. Okay, those are my questions, unless the board has any.
Thank you so much.
Thank
Any board
you.
questions?
Thanks. Our next witness will be Warren Sugg with Civil Design Concepts.
Mhm.
Please state your name and raise your right hand.
Warren Sugg.
Do you swear to tell the truth at this hearing?
I do.
Please continue.
And if I could ask for tech to go ahead and switch over to my device so I can put something up on the screen. Just for the board members' benefit, there are binders in front of you that also have all the materials that are provided to you in advance electronically, but there'll be a couple things we want to highlight. Okay, Warren, I've thrown up on the screen here an overview map. Can you just sort of orient us with where the development site is?
So the site is highlighted in the blue-green, and the aforementioned area to the north is what Stephanie was just speaking about, so subject property area.
Okay. Would you go ahead and walk the board through? I'm going to throw up, this is site plan C201, if the board members want to follow along, but walk us through the project.
Sure. So the site, the main gold building in the middle, that's the one and only building that's residing on site here proposed. That is where the 60 units would be. The gray area to the north is our northern driveway. That connects to the existing Trinity View parking lot. We also have a gray connection that's to Crescent Hill Drive. That's our two main points of coming in and out of the site. You'll sort of notice a somewhat straight in and double-loaded parking area along the east side of Building 1. That's the predominance of the parking areas. You see a hatched-off area on the south edge of Building 1, the only building there. That is the fire lane that the fire marshal had asked that we add in there, as well as a hatched-off area to the north near the picnic pavilion. That's also a fire marshal request. I mentioned the picnic pavilion that's on that very northmost piece, and it's called out with a piece of text. We also have the playground area that's on the west side of the building, as well as a dog park and some benches. The green line that goes along the southern edge or southwest edge is the 20-foot landscape buffer up against those residential properties. And then there are some blue sort of rectangular or square areas, one in the eastern north edge and then the eastern south edge. Those are the two above-ground stormwater control measures for stormwater controls. Water and sewer connections would be on site. We'd be having City of Asheville for water and MSD for sewer. We've already got those allocations, and that's part of the packet.
So Warren, sort of going through the standards here, you've reviewed, are you the engineer of record that's been on this project from the beginning?
Yes.
Okay, and just to give a little bit, I know you've been before this board many, many, many times, but can you give your just brief recitation of your training experience and certifications?
So I went to NC State University, got my civil engineering degree from there, had engineering intern licensure, then 4 years later got my professional engineer's license. That was in the early 2000s. Mainly practiced in the Raleigh-Cary area and then have been here in Buncombe County for the last 12 years.
How many times have you testified and been qualified as an expert in the areas of civil engineering before a Board of Adjustment or similar type body?
More than 50.
Okay. At this point, we would offer Mr. Suggs' testimony that in the area of an expert in civil engineering.
Chairman, no objection, so tendered.
Okay. Warren, how does this project, going through the SUP standards, can you talk with the board about the impact that this project would have on health safety of persons residing or working in the neighborhood of the proposed SUP?
Yes, I believe with the site layout that we've got it, we've given a nice buffer along the area where the residential property is. We've got safe connections to the north and south that we spoke about. We've got safe connections to water and sewer. Stormwater's taken care of, adequate buffering. We're not pushing the land for over disturbance. So I feel like it's been laid out well and is fitting for this area.
Okay. Thinking about the next standard related to impact on public welfare and injury to property or public improvements in the neighborhood, what would your opinion be on that from a civil engineering perspective?
Well, luckily with those existing water and sewer already in place, there's no detriment to the public from service standpoint. This falls well below the threshold for traffic impact studies, so I don't expect traffic to be of any concern. Plus, with those multiple different connection points, traffic can go in lots of different directions.
And from a public welfare standpoint, we have essentially a similar use already in existence to the north of this site, correct? And has been in existence for over 30 years. Is
That
your
sounds right,
understanding?
yep.
Okay. We have a consistent neighboring residential use that is where the buffering is, correct?
Correct.
Okay, and then to the east would be a commercial use, is that right?
That's right. There's commercial services to the east of the parking lot and building.
And this Crescent Drive and the north all access eventually Hendersonville Road?
Correct.
Okay. What is your opinion on whether the proposed project would have any adverse impacts on the surrounding properties due to noise, vibration, odor, or glare?
I don't believe it will have any of those.
I think you've already spoken to this, but any concerns related to ingress and egress to the property considering the 2 entry points and the addition of the fire turnarounds requested by the fire department?
Not at all.
I think you've also hit on this as well, but water and sewer are already in place. I assume electricity and other necessary utilities are already servicing the site in sufficient quantities to meet the project's demands?
They would be, and during construction drawings, those would be finalized.
Can you talk a little bit about exterior lighting and glare type issues that might come up or how they've been addressed in this project?
So exterior lighting would definitely be reviewed during construction drawing review. We'd have to meet the county standards. At this point, we don't have an exact lighting level done. Oftentimes, that can be done by Duke Energy or done by a lighting professional.
And you hit on amenities. I know Rich talked about those too, but just to talk about them just a little bit more, I guess the way I count it, we have the picnic pavilion, the playground, the dog park area, bench seating for residents. Is there anything else essentially for the internal amenities, if you could hit on those?
Yeah, so we've got some mail kiosk areas inside of the building itself. It will certainly have some common areas. Architectural design on that would be finalized and decided, but I'm sure there will be, multiple congregating areas for the residents.
Including the computer room and the community room that Rich had mentioned, correct?
Yep.
Can you talk with the board a little bit about the deviation requested on the height?
Yeah, so 35 feet is the maximum height with the underlying R3 zoning. You've got the architectural elevations that are in the back. It's 42 feet 5 inches to the peak of the roof. So that's what is needed. That's to keep the building in keeping with the other surrounding buildings and not being some sort of flat roof that would stick out. And it's fairly common for three-story buildings to be of that height when you measure from highest adjacent grade to the peak of the roof.
Do you think the addition of this height would negatively impact any of the categories of concerns we've covered in the special use permit standards?
No, I don't.
And just to briefly touch on hours of operation, this is going to be standard hours for a facility that caters to senior residents, correct?
Correct.
Okay.
Now, some of the older folks may throw parties. I'm not a part of that.
Fair enough. We understand you're not leading that. I think we talked about ownership between in the application materials and numbers. Anything else you want the board to be aware of related to the project, lot size or others, from a site development standpoint?
No, I mean, it's a 4.3 acre site. We've got about 4 acres of it that's disturbed. I feel great about the impervious breakdown and the stormwater controls. Parking is adequate and is what the client needs for their users. So I think it's appropriate, and we've got the 60 units, so we are just over that 12 units an acre, but we do have that community-oriented design that we've put into the application.
I think this will be my last category. Can you explain to the board why a traffic impact study was not performed on this project?
Yeah, so 75 residential units or more is the county's standard for traffic impact studies, and this one's 60, so it's less than that.
So not enough to even trigger the need for an assessment from the county regulation standpoint, correct?
Correct, and I think DOT's is 3,000, so it's well below that.
And we highlighted before, this is almost immediately off of Hendersonville Road. That's a roughly 5-lane at
Correct.
this location, correct?
Correct.
Do you have any concerns from a civil engineering standpoint about traffic or related to this development?
Nope, not at all.
Okay. Those would be my questions for Mr. Sugg, and would open up to board questions.
Thank you. Board questions. Joel?
How many parking spaces are allotted per unit?
So total number of parking spaces that we have there are 105 parking spaces, which is the 1.75 to 1 parking ratio.
Okay. The other thing, too, is there public transportation on Hendersonville Road?
I don't have the art or the other maps right in front of me, but I believe there are public transportation areas, and maybe even Stephanie may know of if there's other transportation things. I'm not sure. We can get back to you on it. I'm not sure what all the bus routes are right now.
Okay. The other thing, the building height, are there, I know there's a lot of commercial and other developments. The height proposed for this project, are there other structures nearby that are the same height?
Yeah, the structure that's existing since 1991 is of similar height and look and feel, so it's actually in keeping with it.
Okay. That's it.
Is this development north or south of Airport Road?
It is south of Airport Road.
Okay, because I was just thinking about the bus. Okay, there's an art bus that goes down to Airport Road and then goes over to the airport, but I don't know of an art bus that goes past it.
I can add for the members that I don't believe there is a bus route currently servicing there is Airport Road. This is a little further than that turnoff onto our Airport Road.
You noted the residential units in the barrier. But on the east side, the northern portion of the east side of the property, do you know who owns the opposite side?
The northeast side,
Yeah.
that's Lutheran Services, same group.
That's what I just wanted to confirm. Thank you.
Any other questions? Thank you so much, Mr. Sugg.
Thank you.
Unless there are additional questions, those are the witnesses that we planned on putting on for the board today.
Okay. Any other questions for the applicant on this project? Okay. Anyone here to speak as a witness on this project? For or against? Going twice, going three times? Okay. Any final remarks?
Only to say thank you to the board members for taking the time to review the project, and we're excited about being able to bring more affordable housing to Buncombe County. Thank you.
Thanks so much. We'll close the public hearing and open for board discussion and deliberation and a motion.
Being a senior, I think this is a very worthy project.
This is certainly a number one growth area for the county and for the commission and all of their plans and goals for the next coming years. And this is a huge need in the community, of course. The building height along Hendersonville Road, well-developed area, does not bother me so much coming from that density in that area, and also coming off the road quite a bit behind other buildings. So,
No, I absolutely agree. Not concerned with the height based upon the location and the general makeup of the surrounding properties.
I agree. Any other comments? Okay. You've got sheets between you two and between y'all over there. Yeah.
I'll take this one, Craig. Mr. Chair, based upon the evidence presented to this board and the following exhibits, the petitioner's application, submitted development plan, the GIS maps, the staff report, testimony presented at this hearing, I move that this board adopt the following findings of fact. This matter was properly advertised, is within the board's jurisdiction, is right for its consideration. That this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in the Buncombe County Code of Ordinances, Section 78-621, Paragraph 3.
There's been a motion on findings of fact. Is there a second?
Second.
All those in favor, please raise your hand. Thank you. Any opposed, please raise your hand. That motion passes. Is there a second motion?
Mr. Chair, based upon the foregoing findings of fact and for the reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and modified in this meeting.
There's been an approval motion. Is there a second?
Second.
All those in favor, please raise your hand. Thank you. Any opposed, raise your hand. That passes. Thank you so much. We'll move to a reading of an order on this permit.
Dispensing with the caption, this matter having come on for hearing before the Buncombe County Board of Adjustment at this May 12th, 2026 meeting. Is today the 12th or the 13th? 13th, at this May 13th, 2026 meeting, upon an application for a special use permit to establish a planned unit development for a 60-unit multifamily residential development on tax lot pin 9653-48-3324 by Justin Thorne of Civil Design Concepts, PA, on behalf of Justin Tuttle of Mountain Housing Opportunities, who is the applicant, and Lutheran Services for the Aging, which is the owner. Having considered the evidence presented to this board, including the application, the submitted development plan, the GIS maps, the staff report, the applicant's affidavits, applicant's evidence, the testimony presented, and the arguments advanced by the applicant, the board hereby finds as follows. First, this matter was properly noticed and advertised, is within the board's jurisdiction, and is ripe for its consideration. The applicant applied for a special use permit pursuant to the Buncombe County zoning ordinance to establish a planned unit development for a 60-unit multifamily residential development on the previously stated tax lot pin. The property is located in a commercial service and R3 residential zoning district.
At this hearing, the applicant and any parties withstanding were given the opportunity to offer oral and documentary evidence, as well as to submit questions to each other, county staff, and board members. That pursuant to the Buncombe County Code of Ordinances, the board finds as follows regarding the special use proposed in the application. That the land within the planned unit development will be under single ownership or management by the applicants before final approval. That the density is consistent with the intent of the district in which it is located and conforms to that permitted in the district. That land uses are compatible with and do not violate the intent of the zoning district and do not disrupt the character of the community. That the proposed land use meets minimum requirements for land use development as follows. The minimum lot size required for interior setbacks do preserve the spirit and intent of this section and comply with the density requirements for the zoning district. Proposed heights, as set forth in the application, comply with the spirit and intent of this section with respect to total development plan. Where building heights exceed the maximum allowed by the ordinance, this board finds that unique elements of the development impose requirements for additional height that are not universal throughout the zoning district. This board finds that the minimum distance between buildings will ensure adequate air, light, privacy, and space for emergency vehicles. That the development provides reasonable visual and acoustical privacy for all dwelling units. That the structures located on the perimeter of the development will be set back from property lines and rights-of-way abutting streets in accordance with the provisions of the zoning ordinance controlling the district. This board finds that parking does comply with the spirit and intent of the section. As applicable, this board finds that the conveyance and maintenance of open space, recreational areas, and communally owned facilities are in accordance with North Carolina general statutes, the Unit Ownership Act, and any other appropriate mechanisms specified. The board finds that building envelopes are shown in the submitted plans and depict the maximum expanse of the proposed footprint of the structure. That pursuant to the Buncombe County zoning ordinance, satisfactory provision and arrangements have been made for at least the following as it relates to: the proposed use will not adversely affect the health or safety of persons residing or working in the neighborhood of the proposed use. The proposed use will not be detrimental to public welfare or injurious to property or public improvements in the neighborhood. The proposed use will not cause or have adverse effects on surrounding properties due to noise, vibration, odor, or glare effects. Satisfactory ingress and egress for the proposed use of the property and proposed structures has been provided. Particular attention has been paid to automotive and pedestrian safety and convenience, traffic flow, and control. Provision of off-street parking and loading areas where required, with particular attention to the Buncombe County zoning ordinance, have been arranged for. Provisions for adequate and proper utilities with reference to location, availability, and compatibility have been arranged for. Provision of buffering, if deemed necessary, with reference to type, location, and dimensions have been arranged for. Signs, if any, and proposed exterior lighting with reference to glare, traffic safety, economic effect, and compatibility are in harmony with properties in the district. Playgrounds, open spaces, yards, landscaping, access ways, and pedestrian ways with reference to location, size, and suitability have been arranged for. Buildings and structures with reference to location, size, and use are acceptable. Hours of operation with particular reference to protecting and maintaining the character of the neighborhood are acceptable. That the following conditions are necessary to ensure that the proposed use will conform to the requirements and spirit of the Buncombe County zoning ordinance. First, mechanisms used to guarantee affordability must remain in place for a minimum of 15 years following the issuance of a building certificate of occupancy. Deed restrictions shall include the mechanisms used to guarantee affordability, prohibition of gates or other exclusionary devices or structures, language dedicating areas in perpetuity for community space, greenways, preservation, conservation, or protection, referencing the recorded site plan, language providing for maintenance of all items provided for in order to obtain points with Section 78-650C1 Community-Oriented Development Density Table. Comprehensive site plan shall be recorded with the Buncombe County Register of Deeds, indicating all items necessary to obtain bonuses in density per table, Section 78-650C1. The project must be constructed as depicted in the site plan. Prior to commencement of land disturbance and construction activity, the applicant shall submit a site plan development permit for the entire project indicating the following information: the exact location of all buildings and accessory structures, commercial lighting plan, buffering, landscaping, and parking lot landscaping, retaining walls, easements and rights-of-way, approved 911 road names, any other adjustments, any other conditions of site development approved by the Board of Adjustment, a copy of approved permits from the U.S. Army Corps of Engineers, the North Carolina Department of Transportation, and the North Carolina Department of Environmental Quality where applicable. The master site plan approval shall not replace the requirement of pulling an individual site plan permit for each building or structure within the development. And the applicant must agree in writing to those conditions before the commencement of site work. Based on the foregoing findings of fact, the board makes the following conclusions of law: that the applicant's request for a special use permit, together with the imposition of the conditions found necessary, which are incorporated herein as if fully set forth, meets each applicable requirement of the Buncombe County zoning ordinance. Now, therefore, based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment orders as follows: that the applicant is hereby granted a special use permit to establish a planned unit development on the property as requested, subject to the conditions referenced above, which are incorporated herein as if fully set forth. This is the 13th day of May, 2026.
Thank you very much. Any questions about the order? If not, we'll do a motion.
Motion to approve the order?
There's a motion to approve, and there's a second. All those in favor, please raise your hand. Any opposed? Thank you. It passes. Thank you. Congratulations. We'll go ahead and move right into our next case. It is ZPH 2025-00038 Carroll at Sweeten Creek, special use permit. We're continuing this case from the April regular meeting. And we have Thana Alley to present again.
All right, so this is a review of the continued case, ZPH 2025-00038 Carroll at Sweeten Creek. Applicant is Warren Sugg of Civil Design Concepts. It's located at 99999 Sweeten Creek Road. Total acreage is 26 acres. Served by public water and sewer, zoned R2, and is in the Blue Ridge Parkway overlay with no other overlays present. It's for the development of 305 apartment units across 9 structures, and no deviations requested.
Thank you. Any questions for staff on this one? I believe we left off last hearing having done a few or a couple standing applications.
Yes.
And then we were going to keep that process open for this hearing to do that as well here. Okay, thanks so much. Does anyone here today wish to request standing in this matter? If you'll approach, and we'll swear you in.
Please state your name and raise your hand.
Chris Major.
Do you swear to tell the truth at this hearing?
I do.
Please continue.
Mr. Chairman,
Welcome, sir.
members of the board, my name is Chris Major. I'm an attorney with the firm of Hainsworth, Sinclair Boyd. I'm here on behalf of the Sarah Jane Sumer Revocable Trust. They've applied for requested standing in this matter because they own the adjoining parcel just to the north of the parcel subject to the application. In fact, 2 of the buildings proposed for this development will sit on the ridge directly above their property. So for that reason, they would ask that they be found to have standing to be heard on this matter. The trust at issue, the trustee of the trust is Sarah Jane Sumer. She is here. If the board has any questions for her, she's happy to answer any questions. The site plans in this matter acknowledge that the Sarah Jane Sumer Trust is the adjacent property owner. I don't think that's in dispute. So we believe standing is appropriate. We have the deeds where the property was transferred to the trust if the board needs to see those. But based on those, the document, the site plans provided by the applicant, we believe that standing is appropriate. I'd be happy to answer any questions the board has. I'm also happy for Ms. Sumer to answer any questions the board has.
Thank you. Thanks for being here. Want to ask initially if you all have any particular specific allegations regarding how the property will be impacted by this project, apart from how it's impacted other properties around you.
Sure. Well, specific to my client's parcel, they learned about this about 10 days before the April hearing. They are working to get engineers to assess their site, because obviously the site plans only deal with the applicant's site. But concerns that we've noted, I'll freely admit to the board, I'm a history major and then I have a law degree. Nobody's going to take my engineering analysis, but I do construction law, and in looking at the plans, you notice the zone of disturbance goes right up to the property line on the rough grading plan. In my experience, that's not a coincidence. It'd be awfully coincidental if engineering demand just happened to perfectly match with the property line. Also, you notice that there's several retaining walls right there for the two buildings that sit above the ridge on my client's parcel. There's going to be water coming down that ridge from those buildings. There's got to be drainage for those retaining walls. All that needs to be assessed. So my client would ask, not just for the standing, but also for a continuance to allow them to retain an engineer to evaluate the plans submitted by the applicant and then submit their own engineering witnesses at the full hearing.
Okay, board questions? On the standing piece, yeah. There's been a presentation and an allegation of special damages so far, and they're adjacent to the property, so. Any questions first before?
I'm not even sure if I have a question. I'm just thinking that the allegation is that there's going to be harm to the trust itself, not to any individuals, right?
Well, to the property that's owned by the trust, and the runoff, any erosion that happens, and the trust obviously serves beneficiaries, so there will be people harmed if the property is harmed, if the property is reduced in value. Has several of the beneficiaries here as well, if we need evidence from them on that point.
Okay. All right, any other questions for him?
Yeah, I've got one more question. When was this originally, I forget what the word is, posted?
Yeah.
When did they originally been informed of this?
Staff is looking right now. If you'll give us just a moment, we can let you know.
I'm sorry, I can't hear you.
Staff is looking this up right now. If you'll give us just a moment.
Sure.
March 25th, 2026 is when we would have posted on property.
March 26th, so that's almost 2 months,
25th.
right?
Yes, March 25th, 2026.
And it would have been posted online and also some mailings as well?
Yeah, so on March 25th is when we posted to the property, and then mailings would have gone out on the 27th.
Okay, have you made any attempts in the almost 2 months since it was posted to find experts to come and testify?
Yes, sir. Well, and if you'll recall at the last meeting, one of the beneficiaries of the trust appeared and the standing issue was raised. They didn't appreciate it at the time that they weren't going to, there's a question as to whether they were going to be heard and that they needed legal representation. Once they brought us in after that hearing, we have been talking to engineers, and it's, sort of a chicken and the egg. If you tell them you have 30 days to evaluate and testify and be ready to speak as an expert on this, they're going to say, no way. So, we have not, nobody's committed to do it because of the timeline, but I do not believe if we have more time, we'll have any issue getting someone to evaluate. We've talked to several people about it. People are interested in working on the project. It's just a matter of the timing. Because for the engineer, it was less than 30 days from when we were retained and started reaching out to them before they were going to have to be standing here, ready to put their license on the line to testify to you.
So they did appear last month in an attempt to get standing, and then they've retained counsel now. So they did appear last month, yeah. Any other questions? This is just about the standing matter right now, not about the hearing. Right. Please, yeah. You may go ahead. We have no more board questions now. No.
Sure, a couple things. One, is mine on?
I can hear you. I'm not sure if it's on. There we go.
There we go. Derek Allen with Allen, Stahl, and Kilborn. Brandon Freeman, my law partner, and I represent the applicant here in responding to the standing allegations. A couple things. One, there needs to be credible allegations of special damages. And special damages, as we know, because we do this every month, are unique to this particular property. And that's not happened. There haven't been any allegations of damages yet that I've heard today, certainly not those that would be credible. In terms of the timing question, not only did the county send out that official notice, but a notice was sent by us for a neighbor meeting that we had that would have gone out a week before the county's notice of the first Board of Adjustment hearing meeting, and then that time period from that inadvertent continuance because of timing to today, they've had now 70 days to deal with this directly. In addition to that, late last summer, and I can introduce this if we get into the weeds on it, our folks were reaching out to this property owner about a development related to this project concerning the road on Sweeten Creek and NCDOT improvements and easements, et cetera. So it's been a long time that's been out there. So we didn't have time, sounds a little hollow to me, but the thing that's before this board right now is the allegation or the lack of allegation of special damages unique to this property, and those just simply don't exist.
Any board questions for Derek?
I'm not sure whether it's appropriate to get into my questions regarding timing.
I mean,
I think it's a question of standing. So regardless of when they provided and the time, would you agree that this timing has nothing to do with standing?
I agree.
Okay, then I'll reserve my questions regarding timing until an appropriate time.
I have more of a comment than a question. Is there something?
Please, yeah.
I don't think they proved standing. I think they have allegations, but they haven't shown any proof of damages like you.
So I'll just speak for myself, just that I did hear from the East Family applicant that their property individually might be impacted by runoff in the way that the topography lies between this property, such a property, and theirs. And that might have a financial impact on the value of their property. That was the allegation. And my understanding is they only need to allege special damages and say they'll plan to present the evidence of that later. So that's where I am on it. But,
Well,
is that correct?
And to address that allegation has to be credible. And so you can say lots of things.
The board has to decide, yeah.
And that credibility piece does have with it, and we've discussed this with county attorney, that credibility aspect does have with it some forecast of evidence, and we're prepared to address the stormwater issue to the extent that that's something that the board is interested in, to show that no allegation could be possible in terms of stormwater runoff from our property to the neighbor property in that direction.
So I just want to clarify, sir, you had said earlier, you indicated earlier that a possible extension in the future, later on after this vote for standing, might allow you all time to engage professionals to prove an impact on their property. Is that right?
Yes, sir.
That's what I heard too. But please clarify if we're off base.
Actually very much on base. The issue is that the allegations do have to be credible. The credibility is in the board's purview. So if the board finds that the allegations are credible, regardless of the applicant's position, then you may find standing. However, for example, as I spoke to Mr. Allen a few weeks ago, if the concern is that we don't want this to turn into a mini hearing of what you're going to hear at the main hearing. So
to prove it goes farther than we want to go as far as standing application.
Right. So,
Yeah.
but if you find that there are credible allegations, and I do believe that we have an example from the last hearing where a gentleman made some statements and the board found that he did not make credible allegations.
Right.
In this case, you have a property owner who is adjacent and is asserting issues that the applicant finds are not credible. So you have to decide if Mr. Major is making credible allegations.
Right. That's up to the board.
No, I accept the topo map as a credible piece of evidence, and that gives me the picture of what we're talking about in terms of the flow of water and gravity.
All right. Any other comments on this, on standing?
I'm not sure this is an appropriate time to do this, but there's some photographs along with the application for standing. Could we get an explanation? Because I think that would show, from the photograph of the sort of the topography.
We have a couple exhibits with this application. Is that included already, or is this
Yes, sir.
the
There were
photos.
several exhibits to the application itself. One that has a circle sort of showing the ridge top for the application parcel, and then just below it showing the flow down the ridge to my client's parcel that has the little pinpoint marked where the clearing is. And frankly, I stood there this morning at the bottom of the ridge and looked up at the top of the ridge, and there's going to be at least 2 buildings sitting right up there on the top of the ridge directly above my client's property, along with, if by my count, 3 retaining walls. And that water has to go somewhere.
And just for clarity for us, is under Exhibit 1 and 3, those photos that appear to depict lateral aerials, if you will, of a potential project on that hill.
Yeah,
Those were developed how?
Mr. Sumer, who's one of the beneficiaries of the trust, he generated those as sort of just rough depictions of where the properties are in relation to each other. They're not to scale.
But yeah, not to scale and no professional was engaged on those.
Correct.
These are estimations.
Correct.
Okay, gotcha.
And as to the proof issue, I'm happy to hand up the deeds demonstrating that the trust owns that adjacent parcel. I think the maps submitted by the applicant are sort of concessions that they do, because the trust is called out as the adjacent property owner on all the site plans. You can see the Sarah Jane Sumer revocable trust on there.
Okay, perfect.
I have a question for the applicant regarding that. Does the applicant challenge the ownership of the property and the representation that's here today as being appropriate?
That allegation is credible in terms of the ownership. The stormwater is not, and we're prepared to address that with a forecast of evidence to rebut that.
Bring forth a motion to approve standing.
I think we're ready to move forward with that motion. There's a motion and a second to approve standing. All those in favor, please say aye. Aye. Any opposed, nay? That passes, okay. Applicant's granted standing. Thank you. Yes.
The applicant has received standing. I believe that Mr. Major wanted to make a follow-up motion as a party.
Yes, sir.
Okay.
The trust wanted to move for continuance, just to allow them time to get the full engineering done. I appreciate that the applicant spent a lot of time on this, but the flip side is that the adjacent property owners also need sufficient time to assess the impact on their property and the plans and make sure that they adequately protect the adjoining property owners. And we don't feel like they've had an opportunity to do that to date. It's been, as I said, less than 30 days since my firm was retained. We haven't been able to find an engineer who was willing to show up here today on that sort of timeline and speak to those issues and put his license on the line for that. We believe we will not have any trouble doing that if we have sufficient time for them to do the assessment. There's not any shortage of work for good qualified engineers, so finding somebody that can just drop everything and focus only on this project is a struggle. But we feel like if we have more time, we will not have an issue getting someone here to present our position on that.
As the board thinks about that motion, that request, the next regular meeting of the board is Wednesday, June 10th. What is an appropriate time frame in your mind to get that engineer professional activated?
I'm sorry to interrupt. We would ask at least 90 days. I understand, if the board feels it needs to be shorter, but I think another 30 days where we are with an engineer, it's back where we were in April with another week or so of time. But, so I would say at least 60, but we would hope for more like 90 days, just to give them time to prepare their drawings and sort of be fully prepared to respond to the plans that have been submitted.
More questions before we ask Mr. Allen?
Yeah, I have a question. At our last meeting, someone made a statement regarding notice being provided to the trust in 2025.
I'm glad you mentioned that. I did want to address that. The letter that was referenced it described putting in a driveway and possibly needing an easement or to purchase a small segment of property to put in their driveway. Nothing about apartment complex development, nothing describing the development. For all my clients knew, they were talking about a residence, a single, just a person's personal residence up on the ridgetop. There's nothing in there putting them on notice of the need for a special use permit. And I think if you're provided the letter, you will agree with my characterization that a letter saying, hey, we may need to buy a small piece of property from you to put in a driveway. I don't think that's notice that you need to retain engineers and start assessing what might go up there a year from now.
Okay. Thank you. Other comments, thoughts? Mr. Allen?
Certainly. These processes take a while in terms of getting through, and we maintain that there is no standing here. We think the board has made a mistake, but we are where we are in terms of the continuance. There's already been a 30-day inadvertent continuance because of the timing from the last hearing, yet there's no expert. Now they're asking for an additional 90 days. This is a typical opposition NIMBY tactic in terms of trying to delay the project as long as possible. We're here, we have engineers here today, we have experts here today. They were here last month, and these kinds of things in terms of the cost, both in terms of time and money, are substantial and thwart the thing that we need the most in our community right now, which is additional housing resources. We object to any continuance, would like to be heard today.
Okay, thank you.
Question on when did the applicant engage the services of an engineer for this property? How long ago? I think you know where my question is going. How much time did the applicant engage, and how long did it take the engineer to provide their material?
While I'm waiting on that date, I am going to read the opening paragraph from this letter that went out in July of 2025. I hope this letter finds you well. I'm writing to introduce myself and reach out regarding your property located at 1663 Sweeten Creek Road in Asheville. My company currently has the adjacent property to the south of your property under contract, and we're in the planning and design stages for its development.
No, my question was regarding the applicant's employment of their own engineer and the time frame that was necessary for that engineer to bring forth the material as a part of the application.
I understand, and they're looking that up. I was just giving
Okay.
some context to rebut what was there since it's my turn on the microphone.
Yes, please.
Yeah, the Property Owners Council, we just granted standing based on some credibility that it could suffer damages. And to me, logically, we should be allowing him to bring up experts to verify those damages. And especially, I keep hearing development's gonna be up on top of the ridge, and the property owner is gonna be below the ridge. And usually water runs downhill.
Yeah, thank you for that. We're going to hear from the applicant in a minute as far as the answer to that question's been posed about their timing.
The applicant's engineer has been working with the applicant for a year in terms of this project and other projects, but could provide rebuttal on this for a month. That was some volunteered information.
I'm sorry, I didn't quite hear the rest of that. It's the last part of that sentence. Can you clarify?
The engineer added that rebuttal time for something like this would take a month.
Okay.
So it took a year for the applicant to produce the engineering material.
No, that's not how development works. This engineer works with this applicant on multiple projects. This is the second project that I was involved with, one in the city and one here, not to mention other sites that were looked at by this. So to pinpoint when this development starts from start to finish is really not the right question and doesn't produce the right answer.
Okay, so I don't know if we're going to get an answer
I
there.
don't know,
Let's,
I'm just trying to make the point
Right.
that if 90 days, I think that your engineer and your applicant expended more than 90 days to present the material that's a part of the application. And if the party withstanding is asking for 90 days, that probably is less than the amount of time that the applicant used with their engineering firm.
My answer to that is the engineer, and I could put Mr. Sugg up here, said that he could do that in less than 30 days.
so with that testimony, let's open up to board discussion. We've had some already about the timing of a potential continuance on this. First, whether it should be continued, and then also a time frame. We've heard 60, we've heard 90. And we've heard 30, as far as the applicant having, yeah. Thoughts?
Yeah, I was just going to say, the argument that it's difficult to find an engineer, I mean, I find that argument to be credible. I don't think they could walk into an engineering place and say, sure, come with me and they'll, check this out. Whether it should be, I think more than 30 days is credible. I'm a little up in the air about whether it should be 60 or 90. I mean, my quick reaction is to, split the difference and call it 60.
I would agree with those general thoughts and just think 30 is too low. So either 2 or 3 months, I would think, given the time frame on the whole entire project and the application period and the likely engagement and timing of what an engineer could produce for this kind of hearing, 60 might be okay. Board thoughts?
May I say something?
I'm sorry. You swear you in? I know you already sworn in last time. Yeah, let's go ahead.
Please raise your right hand and state your name.
Adam Samir.
Do you swear to tell the truth at this hearing?
I do, yes.
Please continue.
Thank you.
Thank you.
I came in last hearing, not knowing what was going on. I told the board that I would come with legal counsel. We have 3 attorneys here. There is no stall tactic. I understand stall tactics are very common in this type of proceeding. We're not joking around. We have our family farm, a historic piece of property that is below a ridge line and a highly elevated proposed development site. Engineering, I've spoken with MAIs, they're booked for months and booked for years, because I wanted to get an MAI also involved. Getting an engineer to study the plans, look at his own plans, come to our property and study the site is very important, and we need to get somebody who has the time to do this. 90 days is the minimum amount of time that we need for this. They had over a year. We're asking for 3 months. I don't think meeting in the middle of 60 days is not enough time for us. I mean, I wanted to establish credibility that what we say we will do. So last hearing, I said we would come with legal counsel. Now we're here with 3 attorneys. We will be here with an engineer and experts 3 months from today to defend our property.
Board questions, thoughts? The applicant.
It will take some time to retain an engineer, and obviously, they're going to need some time to do some work too. So I'm leaning towards, I think 90 days in the interest of fairness for the whole process is not unreasonable.
I'd like to point out that they've already had 60.
Let's get the board thoughts first. Any other board thoughts based on that?
No, I concur with Mark's thoughts in terms of having recently, personally, dealing with and finding and getting them out there and getting the report, and it does not happen quickly.
And Mr. Allen?
If 90 days is what they were asking for, and they haven't done anything in the last 30 days in terms of attaining, then I think that should be credited against them. And I'm only counting that 30 days since the last hearing when they knew what was needed. It's been over 60 days since they knew about this process, and it's been since last July since they knew that the project was coming. When we go through these processes, and this is the thing that this board needs to understand, again, we know what the needs are in this community in terms of housing. Everybody talks about it, you read about it in the paper every day. When we go through the process with the county, we have to put a piece of property under contract, and that contract has contract deadlines. Those contract deadlines are known to sophisticated opposition parties like someone who shows up with 3 attorneys. They know that there are contract deadlines that have hard money that has to go down. They have closing dates. They have due diligence termination dates. And when you start to pinch those dates, then you end up with a problem as a practical matter in the development world when we're trying to deliver housing units to this community. And so when you stretch that out to a 90-day time period, just willy-nilly in this kind of process, you are thwarting that and thwarting the need that we're trying to put out there.
Board thoughts?
Yeah, just one thought on that last comment. I'm as aware as anyone of the need for housing. Good housing probably lasts centuries. And I don't think the difference between 60 days and 90 days is terribly relevant in terms of whether or not we're getting housing.
Okay. Joel?
I have a comment too. I realize there's a need for housing, but I don't believe that's under, as far as us having a quasi judicial responsibility on the board to consider needs for housing. The other question I have, when do you have to close on the property?
While he's confirming that, if I could just speak to the timing issue. I have the soil survey that they've submitted with their application. It's from June of '25. Their rough grading plan was October. I mean, it took them 4 months, 5 months to get their plans from their survey, and yet they're arguing that 90 days is just an absurd overreach on our part to respond to their plans. I think it's a perfectly reasonable request.
I've got a question. Have you guys defined a scope for your engineer and what they're going to be looking at? I feel like are they going to review this plan and provide testimony? Or are you coming up with your own plan? There's a vast difference in timing if we're talking about them coming up with a development plan or some kind of rebuttal development plan. But if you're looking at just the merits of this application, that's not a 90-day process. That is a quick process. That is a, days or weeks process, not months process.
I would compound that. Not only that, but you guys are trying to rebut on some level what they presented. And a huge amount of that timing is gaining that approval, which obviously they're not in control of. You wait and wait and wait. So if I'm not misreading here, what's going to happen is you're going to hire professionals to review what has been done. And that's fair. I get that. That's what we're doing. But to say, well, it took them this long, I mean, there is a lot more to creating and getting approvals than getting a review. And I think that's what we're talking about, is getting a review, and that's fair.
And for our experts, I think there's two components. There's reviewing what they've submitted, particularly the two buildings that sit right above them, just up the ridge. I mean, you're standing at the bottom, you're going to, in the wintertime when the leaves falls for certain, you're going to see those buildings every day.
All right.
And there's also walking
Objection.
my client's property.
Sorry, there's an objection. What's that? On what grounds?
He's talking about something, A, that's not true, B, that he has no technical expertise to opine about. If we're going to get in the hearing, let's get in the hearing, but.
Yeah, let's broaden it out a little bit.
Well, I was asked what the scope of what we would have an expert look at. So there's reviewing their parcel and what they've proposed. The part that's completely absent from theirs, that ours will also focus on, is the impact on our property, assessing our property. There's been no study of our parcel by an engineer. There's been no soil analysis. There's been no erosion, stormwater analysis of our parcel. That has to be done. That's stage one. They didn't do any of that because they don't want to know the impact on our parcel, because that can only hurt their application.
Objection.
So let's move on there. And are you all leaning towards 60?
Well, I'd like to hear
Yes.
your response to that. If the scope is, as he articulated it, Gabe, to have an engineer come and evaluate their property, the soil of their property, potential implications to that property if there was runoff from the uphill property.
I think we're talking about two different things. I think we're talking about evaluating the merits of this proposal in the way the regulations or stormwater regulations are, that if they meet, they're required to meet, that I'm stating what the regulations are. What he's talking about and evaluating, that's their property development. It's not material to this case. That's another case.
Unessential, yeah.
It's
That's
not,
right.
we're talking about specifically what is in this application for an engineer to review and determine on their professional opinion, does this have detrimental impacts that are unique to this property? That's it. I mean, the soils of their property, the view sheds, that's all controlled by county zoning, stuff that we don't even look at. That's an administrative process. So I think personally, it's my opinion that once you have one engaged, 90 days is way too long.
I, having been through this process
Way too long.
many times, I concur.
30 days is plenty.
Okay, let's hear one more round real quick from each, and then we'll go ahead and close this and vote.
And there has been an allegation that we don't suffer damages. And so I think how the runoff that they're going to create affects our property is relevant to our ability to appear and object to the application. It's relevant to whether their plans are adequate, because we need to know, have they considered the specific conditions of our site when they said that they're going to disturb up to the property line? Is that sufficient? Did they actually, for their plans with their walls and those buildings, do they actually need to come onto our property to adequately grade? I noticed that the retaining walls, and again, I'm not an engineer, but the retaining walls on their plans are 20 feet. Well, that's the maximum height before you have to terrace the walls. Now, is that engineering concern that's dictating that height, or the fact that they don't have the horizontal space to terrace the retaining walls? Because
Those all points may be relevant later on in the process, but essentially the core duty of the board is to evaluate whether the applicant has a burden of proof, and they're going to make their case, and then they can be challenged by you all, and it can be disproven. So that's kind of what we're going for here, rather than saying what else could be. That's not what the board's going to be considering. So with that in mind, Mr. Allen.
Can I say one thing before we go to the opposing counsel?
Yes, sir.
We're talking about two things. If we are just going to review their engineering plans, I agree with you, 90 days would be too long, but that's not exactly what we're doing. We're talking about how the stormwater runoff will affect the neighboring properties, a study that they have not done. They don't want to do that.
Objection.
I'm not done.
No,
I'm not done.
objection.
I'm not
because-
done.
But you
I'm
can't
also-
talk about things that.
What's the objection? I'm sorry.
The objection is he's forecasting evidence that is wrong and not credible. They're not qualified to
Talking
opine
about the scope of work.
And if we're going to
Just a
get back to the standing piece, where I said this board got it wrong and that there has to be a forecast of evidence in terms of the credibility, we were prepared for this stormwater piece, and we can show there is no stormwater runoff at all to this property, and we have had engineers do that, and we have studied it, and we can show it. Had we been given an opportunity to rebut their standing of allegation in terms of the credibility, air quotes intended, of their damages allegations, we'd be able to show there is no stormwater runoff that's going to happen on their property from this development. And I'm happy to put Mr. Warren Sugg up right now, and they can cross him with one of their 3 attorneys, or all of them if they'd like, and we can show what we prepared.
Okay. Let's briefly hear what you're planning to order if we give you time enough beyond 30 days.
Well, obviously, one of the relevant factors for us is how it affects our property value. So we need to study their plans, where the water's going to go. Is that going to cause erosion? Is there additional retaining walls, stormwater management that's required? I think the applicant's wanting to have it both ways. He's talking about the evidence he can forecast with the engineer, but we're not prepared because we just have lawyers here. That's the reason we're asking for more time. We haven't had a sufficient amount of time to retain the engineer and have them get up and speak to these issues. If he doesn't want to hear it from me, I agree, we should have a hearing in 3 months, and we'll have all the witnesses then, we'll have all the arguments made, all the evidence laid out, and the board can make its decision based on those witnesses.
Thank you. Mr. Allen?
I don't have anything further. I've said what I wanted to say. If we want to start the hearing and talk about stormwater runoff, Mr. Sugg is here, and we can get into that. If not, I think what's been forecast in terms of the standing, it's fine. The board's made their decision on that. We would ask for as short a time as possible because we do have real-world contract obligations that start to kick in that we have to deal with.
Thank you so much. We'll open up to board discussion. Joel?
Yeah, and question to you before, when is?
So Joel,
Close on this property?
Joel, can we, we're doing board discussion. If you want to summarize your thoughts for a potential continuance
Okay.
or not. Okay.
What do you think, Joel?
What do I think?
For their continuance, not for them, but for the benefit of the board.
Yeah, I'm for continuing it. I think there's 2 parties involved. They should both have the opportunity to present their experts. And as we voted for standing, we found the attorney for the property owner that we found there could be credible evidence. And so my feeling is that, and I still feel like I haven't really gotten an answer. Are they closing next week? Are they closing within 30 days? So based on the information I heard, I would vote to continue it. And I'm willing to go 60 or 90 days.
Other thoughts or motion?
I think 60, 90 days is too long. If we vote for a continuance, it should be 30.
Okay.
We have two decisions or one?
I think we try a motion.
I'll bring forth a motion to approve the request for continuance.
And for what meeting would you like that to continue
That
to?
would be the second question.
Oh, got you, two motions, okay.
Okay, can I make one suggestion on that?
So real quick, I'm sorry. We have to, in this motion, continuous motion has to be to a date certain, if I'm not mistaken. So we have to, and let's please not schedule a special meeting for this one.
And then I will,
Okay, can I make one suggestion?
Yes, please.
I don't mean to interrupt you, but because there's a disagreement on this in the board, can we start with a motion for 90 days and see whether that passes?
That's what I was tempting, yeah.
go right ahead.
Okay, I move that we continue this for 90 days.
Okay, there's been a motion on 90 days. Is there a second?
Second.
There's been a motion and a second. All those in favor, please raise your hand. You're in favor of that motion?
No, I'm not.
No, you're not, okay. And anyone against, I'm sorry, that motion? Against? Thank you, that does not pass. Is there another motion?
I move that we continue this for 60 days.
Okay.
Second.
A motion and a second. All those in favor of 60 days? And any opposed? Any abstentions? Okay, thank you. That motion passes. So we'll see you all, hopefully, July
Chair.
8th. Is that right?
Chair, a
Yes,
couple of
please.
things. One, while we're here, it seems like we might want to address any other standing applications. If not, that seems like a wasted opportunity. And two, before I forget, I want to register our objection just for the record so that we have something to do in the next 60 days, that we object to the finding of standing based on the fact that this board can granted standing without hearing any sworn testimony, and the affidavit submitted in support of the standing application includes at least two AI-generated exhibits.
Your comment is on the record. Is anyone else here to assert standing in this matter? Yes, ma'am? And can I get a show of hands, anybody else in addition to the lady wishing to assert standing? This is the last one we'll hear. Second, 3 times, thank you. Yes, ma'am. If you identify yourself and we'll swear you in.
Chair, before that, we received some standing applications. Would you prefer us to go through the standing applications we received first and then poll the audience to see if anybody else would like to assert standing?
Let's call those names after this standing
Okay,
applicant.
I just want to make sure.
And then we'll close, yeah.
I am
I'm so sorry. Please state your name and raise your right hand.
Debbie Ebner.
Okay, do you swear to tell the truth during this hearing?
I do.
Okay, please continue.
I got your first but not your last name, I'm sorry.
Debbie Ebner.
Thank you so much. Welcome.
I put in an application. I'm on the website, so I don't know if I need to be here, and I'm not familiar with all the proceedings, so I want to do things right.
You're in the right place.
Okay.
And very
If you'll-
briefly, excuse me.
Yes,
but
please.
As part of her standing application, she did have 2 attachments that did not make it to the website. So if the board allows me, I'd like to just show those to the board as part of her standing application. I can pass those to you.
That sounds good. Let's pass it to the applicant and the standing applicant as well. First.
I represent Cimarron Homeowners Association.
Are you an attorney licensed?
No,
in North
I'm the president of the HOA.
Okay, so you'll speak
So I
today.
really appreciate the
Before you
volunteerism.
continue, I'm sorry, let's clarify that you're going to speak as an individual, as a member of that association, but not representing them, okay? You can't represent an association without being an attorney.
Okay. Then I speak as
A
an
resident,
individual.
yeah, there you go. Thank you. You may continue, yeah.
Okay.
Sorry.
There are two creeks which run through the property, the subdivision property. One is an above-ground stream and one is an underground stream. And the concern is the runoff from the proposed development
I understand.
having adverse effects.
As part of the standing application process, we're just going to focus now on the reasons you might qualify for standing in the first place. So whether you have a standing, a reason to assert standing in this matter, and that would be something individual to your property, how this development might affect your property apart from the others around you. If there are commonalities that affects it the same way, then not those, but things that might impact your individual property.
I would have to say no, and I will resubmit.
There is an opportunity at the end of the hearing that the board will open up for witness testimony.
Okay.
So this will be clearly at the next hearing, of course, we'll be continuing.
Understood, and thank you.
That might be the best way to do it. If you want to withdraw that one, that's,
Is that also an online application?
what's that?
Is that also an online application?
No, you're fine to appear in person and we'll collect.
Thank you.
But the folks that did apply for standing will call you first to be a witness at the first part of that witness testimony.
Thank you.
As a courtesy. Thank you so much. We'll consider that one withdrawn, and we'll move to the next standing application. So what was the next name on our list, staff? Mm-hmm.
There's no outstanding standing applications.
Was Battenhorst
He was
also?
denied last
That's right,
hearing.
okay.
Yeah.
And so we're a clean slate. Okay, good deal. Anyone else in the audience here to assert standing in this matter? There'll be a time for witness testimony in the next portion of the hearing as we continue it. Going twice, three times? I'll make a motion that we close the standing application period.
Second.
All those in favor, please say aye. Aye. Any opposed, nay? Thank you, that passes. Do you have a comment, Mr. Allen? Or do you want to make your?
I do not.
Okay, perfect. We have already continued this with a motion, is that correct? Correct. Okay, so we're all set. Thank you all so much, and we'll move to the next case here. Before doing that, we'll do a 5-minute.
5 minutes?
5-minute break.
5 minutes.
I think we are ready to come back to order for a variance. CPH 2026-00014, the Southern Towers Woodmere variance. Jillian Phillips is back. We're very excited.
Please state your name and raise your right hand.
Jillian Phillips.
Do you swear to tell the truth at this hearing?
I do.
Thank you.
Welcome.
Welcome. Just to explain a little bit, when we get cell towers, they usually, mostly, 99% of the time have to apply for a variance in height because they usually exceed the height within the underlying zoning district, which makes sense. In order to get coverage, the cell towers need to be pretty high. So in order to move on to the special use permit for the cell tower, we first have to do the variance for the cell tower. So I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, so admitted.
Okay. This is a review of ZPH 2026-00014, Southern Towers Woodmere variance. The applicant is Pat and Han of Baker Dolanson on behalf of Southern Towers. The project is located at 2061 Upper Laurel Drive, which is in Luther Ridge. It's sort of in the middle of Luther Ridge in the center of the property. And the total acreage of the Luther Ridge site is 135 acres. The project will be served by public water and septic. The property is zoned Conference Center Resort District with no zoning overlays. The variance application proposed is an increase in height of 54 feet to allow a 150-foot monopole cell tower with a 4-foot lightning rod.
Please.
I got a question, and I think it's just a typo, but I just want to make sure my assumption is right. In the staff report, there is a notice under Section B, Project Summary, a reason for request. The applicant is constructing a single-family home in a location that differs from the approved site plan.
That is a typo.
Okay.
No single-family
I didn't
homes,
see a
cell tower.
single-family home referenced anything. Okay.
And one more question briefly. Without discussing particular prior projects, what is a good range the board should be thinking about in terms of typical heights across the county for other towers?
So
That's the best
154 is
way.
probably a little low. They're usually around 190 feet. They're usually right under our limit, which is 200 feet. They're usually around 190.
That's helpful. Thank you. Is anyone here wishing to assert standing in this matter? Any standing applicants? Do we have any filed with the staff? I'm hearing no standing applicants on this one.
Standing application.
Wonderful. Anyone in the audience wishing to assert standing? Going twice, going 3 times. Thank you. We'll introduce the applicant. Welcome.
Thank you, Mr. Chairman, members of the board. My name is David Blue. I'm here on behalf of the applicant, Mr. Hahn, and in turn, Southern Towers. I'm actually here to introduce my colleague, Nick Steinhaus, who's going to be able to speak more about the application and introduce our witness.
And you're with the firm, or?
Yes, I'm with the firm Baker Donaldson, and so is Mr. Steinhaus.
Wonderful. Thank you. Yeah.
Should I get up there?
Yeah, please, if you want to. Yeah, if it's more comfortable.
My name's Nick Steinhaus. I'm an attorney with the law firm of Baker Donaldson. Can you all hear me?
Yeah, he's an attorney, so I think we're all set, right? Yeah. Yes, we can. Thank you.
So our client, Southern Towers, is, as stated, proposing to build a 150-foot communications tower on the property owned by Novus Way Ministries. It is a 135-acre parcel, which is just humongous, heavily wooded, lots of natural vegetation and brush. I think you've got a balloon test and some other supporting documents which we've submitted as part of our application. Having been to the site a couple weeks ago, we had a neighborhood meeting. Over 200 notices were sent out to adjacent property owners. If we need to provide proof of delivery of all those notices, we're happy to do that. But we had a neighborhood meeting at the site. Only 3 people showed up, and they had some just very general questions, which we were able to answer, and we gave them a little bit of food and something to drink. And but everybody seemed to be on board by the time that was over with. As far as the variance standards go, so we've got to first establish that there's an unnecessary hardship will result from strict application of the ordinance. As Jillian stated previously, cell towers pretty much always have to have a variance in Buncombe County. We are in the CR district, the Conference Center Resort District. That has the highest height limitation, which is 100 feet. Unfortunately, here, the tree line exceeds that 100-foot height level. So in order to have a tower that, the antennas from the carriers on the tower have to have a line of sight to each other. So one tower to the next tower, they have to have a line of sight. We have to extend above the tree line. What we are proposing is an additional 50 feet so that there's clearance. We will have somebody from Verizon Wireless come up and testify as to the need to have their particular antennas at 145 feet on the tower. But we will also have room for 2 additional co-locators, which, and my client, Southern Towers, will be marketing space on that tower to AT&T and to T-Mobile and try to get, other carriers aware of the fact that the tower is there and available for their use, which is consistent with the ordinance, which, mandates that wireless carriers go ahead and first seek to co-locate on existing towers before they try to go and build their own. In this particular case, there was nothing available in the area, which is covered by the SUP part. So going on to the next standard, which is to establish how the hardship results from conditions that are peculiar to the property. This again goes to the height of the existing tree line, which extends over 100 feet in the air. And the general topography of the property, it's, heavily hilled and changes in elevation. And that's, I don't think we can show in any other way that, the actual conditions are peculiar to this particular parcel of property. The next standard is to explain how the hardship did not result from actions taken by the owner or applicant. Again, this kind of overlaps with the previous requirement in that neither the owner nor Verizon or Southern Towers did anything to create the changes in elevation on the property or the existing natural vegetation and existing height of the tree line. Both of those are naturally occurring. And I think it's probably in everybody's best interest that we not go chop down a bunch of trees in order to get a tower up there. Finally, indicate how the variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and justice is achieved. Again, as previously discussed, Section 7247 of the ordinance strongly encourages multi-carrier communications towers. You don't want to end up with one geographic area being served by 3 or 4 separate one-carrier towers. And that's what you're going to end up with if we can't get sufficient height on this particular tower. So we're serving to reduce overall the number of towers, which is strongly it's a strong implied objective of the wireless communications tower ordinance. And then that's pretty much it for the 4 requirements. I'm going to ask that Sam Kamel with Verizon Wireless come up, and he's going to explain to you why we need why Verizon Wireless in particular needs the height of 145 feet, where their antennas are going to be located. Again, the overall height of the tower is 150. You've got a 4-foot lightning rod on top of that. And then Verizon's antennas will actually be mounted. They'll be the top carrier on this tower. They'll be mounted at 145 feet. I'm going to hand out some maps which show the expected improvement in coverage for Verizon Wireless for this site. So I'm going to bring these up to you all, and then I'm going to have Sam come up if that's okay.
Thank you. Yes.
And was this part of your application that you sent?
This was obtained after the original application was submitted.
Okay, do you have a copy that we may have?
We do.
And hearing no objection, we will accept this as Exhibit 1. At this document, Exhibit 1. Welcome, sir. We'll start by swearing you in.
Please raise your right hand and state your name.
My name is Sam Kamel.
Do you swear to tell the truth at this hearing?
I do.
Thank you.
Thank you.
Thank you. Thank you for allowing me to speak here. So, I'm an RF engineer with Verizon, and as mentioned here, we're requesting that the height of the antenna to be at 145 feet, which means the tower to be at 150 feet. And just very simply, if you look at in the graphs that you have right now, and if we can look at the last page, please, you can see that we did signal analysis before the site is to be built and then after. And where the black circle is on the left, where you see pre and post, and I'm looking at the plus pre and post Verizon 5G coverage at 145 height. And again, 145 is where the antenna is proposed. So if you look at on the left graph, you see that the black circle is surrounded by yellow and orange colors and some green. But you see, after the site is built, the coverage has improved vastly in that area. So this is where you see on the right side, that's the post. So the colors identify where users can make a call. So the users, so we have 3 colors. We have green, we have yellow, and we have orange. We have in building and in vehicle and on streets. So you can see very easily how the coverage improves once the site is built in that area. So simply, that's that's the reason why we want the height to be at that level, so that we can have the coverage that's introduced in the graphs here.
Do you all currently allow other carriers to share your bandwidth on your towers? Sorry, not on your towers, on your devices? Do you sublicense to other carriers?
So each carrier has its own license band. So each carrier operates in their own license band.
Okay. So you wouldn't have, like, say, not a T-Mobile device or a user hopping on a Verizon signal? That doesn't happen.
There is something called roaming, where you allow users from other carriers to roam in areas where they do not. And this is something beyond the scope of this prediction, where this is like a business where you have roaming agreements between the carriers. That's about it. But okay, as far as operation of the signal, each carrier operates in their own specified bandwidth that they're licensed for.
Okay, thank you. questions? Yes.
Did your role with this project include determining where the footprint of the tower would be located on the property?
Where the footprint, meaning like where the expected coverage of the signal.
No, where the expected location of the tower itself on the property? Did his scope include that?
No, I can speak to that.
Okay, I just wanted to clarify. Yeah.
Sure.
So, and will you have someone who will speak to that?
Yep. Can you all hear me? Okay, so, actually, I was going to say, I'm going to call Donnie Pell with Southern Towers.
Yeah, we'll hear him next after.
He can
Okay.
come.
Okay, yeah.
I just wanted to clarify if this gentleman was the expert for that, but I didn't think so.
Yeah, my role is the RF engineer, so anything has to do with signals, with coverage, all that I can answer, yeah.
I have just one point of clarification. It was mentioned that the necessary height was because of the line of sight between two towers, but we're not talking about tower-to-tower communications here. We're talking to wireless carriers, right? I mean, it's mobile cellular communications, things like that.
Yeah, the line of sight that we are referring to is to have coverage to the specified area. So when you have, for example, a tower at a specific height, you have antennas installed at a specific height, and these antennas propagate signal to the roads, to the building, and so forth. So the best signal or the best coverage to these areas is when you have a clear line of sight to them. If there is blockage by foliage like trees or by buildings like that, the signal decreases dramatically. So when we talk about line of sight, mainly we focus on the line of sight to the areas that is intended to be covered.
Thank you so much, sir. Appreciate you.
Oh, you're very welcome.
All right, so now we'll have Donnie Pell with Southern Towers come up, and he can answer the questions regarding exact siting of the tower on the property.
Welcome, sir. We'll start by swearing you in.
Please raise your right hand and state your name.
Donnie Pell,
Do you swear to tell the truth at this hearing?
I do.
Thank you. Please continue.
Thank you. Questions for, can you state your question? Yeah.
If I read the topo map on this property, it has a variation of roughly 200 feet in elevation.
It's pretty rough over there.
Yeah. But then as I looked at the topo map and then the plan map, it appeared that the tower will not be on the top.
It will not.
And so the choice of the location of it being not on the top, walk me through why it was not on the top. Because if 200 feet of elevation you get on the top.
Right, and that's a very good question. So kind of the way we all go about doing this work, Southern Towers has a relationship with Verizon, and we have had for years. So we'll get what's called a search ring from them. Very small ring on a map says, hey, we need a site in this area. So then we get site acquisition people to go out and try to find a piece of land, one that is zonable, constructible, and meets the RF criteria. Well, at the top of the hill up there, that's also up there where the chapel's at. And so working with Novus Way, and they've got lots of things they do up there on the top of the hill that probably wouldn't fit real well with the tower. So we put the tower back in behind the maintenance facility. It's about the only place you're going to be able to see the towers if you come up the road to the maintenance facility. So in trying to keep with, the community and being good corporate citizens, we try our best to put these things in a place where they're not as obvious.
And do you all have any plans for camouflaging the tower at all? I know it's not visible from the roads nearby, but within the property it is visible, of course. Any plans on making it look like a tree or, that they
We do
do
not.
sometimes? No.
No.
Okay.
The other question, I'm not sure again if it's relevant for your role with this, but I believe there were a number of questions responded to by the applicant that took credit for the vegetation and that would shield or provide a visual shield. Is there any assurances that that vegetation will never be removed?
So that would be part of the telecommunication permit that got issued, and if they ever went in and, mowed down part of Lutheridge, which I doubt, then they would be in violation of their telecommunications permit, and we'd start enforcement.
Okay.
I
So
can
there
assure
are
you we will not-
protections in place on that, okay.
I can assure you, we will not go in there and mow down trees.
No, I assume you wouldn't, but somebody might.
Somebody might, and it's very, like, on these very large tracts of land that are heavily wooded, it's very common for them to use the vegetation that exists as opposed to the screening requirements for a tower, which is just 2 rows of evergreen trees. It's really not meant to shield, like, the view of the tower, because towers are so tall. It's meant to shield the view of the equipment down on the ground.
Other comments, questions, thoughts? Thank you, sir, so much.
Thank you.
So that is what we have. I mean, we have other folks who can speak if there are specific questions regarding the variance portion of the application. And I'm happy to answer any additional questions you all might have, or at least point you to the right person who can respond.
Other questions for the applicant? I'm all set, too. Yeah. I think we're all set.
All right, thank you.
Thanks so much. Anyone here to speak as a witness on this matter? Anyone here to speak as a witness? Third call. Okay, thank you. We'll close and open up for board discussion and deliberation and a motion. Yes, sir.
Yeah, just to follow up kind of on your comment, in a previous life, I worked for the utility and telecommunication industry dealing with these and seeing them look like trees. And I think them looking like trees, you know it's not a tree.
You're
Okay?
right.
So,
Thank you, Joe. Other questions? Other comments? A pretty straightforward application. We've seen these come through periodically over time, year to year, and they're needed, of course, for coverage.
And make a motion to grant the request for the variance.
There is a motion to grant the variance. Let's look at the sheet and see if we have a findings of fact first. There's 2 motions, yeah, 2 motions on this one.
We got the variance. Sorry about that.
Findings of fact.
Mr. Chair, based on the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted plan, the GIS maps, the staff report, testimony presented at the hearing, I move this board adopt the following findings of facts: that this matter was properly advertised, is within this board's jurisdiction, is ripe for its consideration, that this application, together with the conditions proposed by staff and/or the board and agreed to by the applicant, if any, does meet the requirements for granting the variance contained in the Buncombe County Code of Ordinances, Section 78-6214.
There's been a motion on findings of fact. Is there a second?
Second.
All those in favor, please raise your hand. Any opposed? Raise your hand. That passes. Thank you.
Based on the foregoing findings of facts and for the reasons set forth therein, I move that the requested variance be approved and that staff be instructed to draft an order consistent with this motion approving the permit with any agreed-upon conditions for review and the execution by the chair, acting chair, or such person's designee on behalf of this board.
There's been an approval motion. Is there a second?
Second.
All those in favor, please raise your hand. Any opposed? That passes. Thank you very much. Moving to reading of an order on this variance.
Dispensing with the caption and the recitals, having considered the evidence presented to this board, including the application, the submitted development plans, the GIS maps, the staff report, site plan, applicant's submittal packet, and the arguments advanced by the parties, the board hereby finds as follows. Number 1, that this matter is within the board's jurisdiction and is ripe for its consideration. That all required notices were sent, proper signage was posted at the property, and sufficient legal advertisements were published. Third, that the applicant has applied for a variance pursuant to the Buncombe County zoning ordinance to request an increase to the height of a proposed telecommunications tower on pin 9653-38-0860. That at the hearing, the applicant and any parties withstanding were given the opportunity to offer oral, documentary evidence, as well as to submit questions to each other, county staff, and to board members. 5, that an unnecessary hardship would result from the strict application of the zoning ordinance. 6, the hardship does result from conditions that are peculiar to the property. The hardship did not result from actions taken by the applicant or the property owner. 8, the requested variance is consistent with the spirit, purpose, and intent of the ordinance such that public safety is secured and substantial justice would be achieved by granting the same. Based on the foregoing findings of fact, the board hereby makes the following conclusions of law. The application, together with any conditions referenced, satisfies the requirements for satisfies the requirements for granting a variance contained in the Buncombe County zoning ordinance. Now therefore, based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment hereby orders that the applicant's request for a variance from the zoning ordinance of Buncombe County on the property is hereby granted this 13th day of May.
There's an order that's been presented to the board. Any questions on that? Any motion on that?
Motion to approve?
There's been a motion to approve. Is there a second?
Second.
All those in favor, please raise your hand. Any opposed? Raise your hand. Thank you. That passes. Our last case today is EPH 2025-00016. Oh, look, Southern Towers is back for a special use permit.
We're here.
Today. Everybody's here. Fantastic.
Do I need to be sworn in again? No, okay. I only do this every once in a while for a cell tower. I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, so admitted.
This is a review of ZPH 2025-00016 Southern Towers Woodmere Special Use Permit. Applicant is Patton Hahn of Baker Donaldson on behalf of Southern Towers. Property is located at 2061 Upper Laurel Drive. The acreage of the property is 135 acres. The project will be served by public water and septic. The property is zoned Conference Center Resort District with no overlays present. And the special use permit is for a wireless telecommunications facility, including a 150-foot tall monopole with a 4-foot lightning rod within a 45-foot by 45-foot fenced compound area. And the proposed staff conditions are: project must be constructed as depicted in the site plan. A telecommunications permit must be submitted and approved prior to submitting the site plan permit and submittals of building permits. Prior to commencement of land disturbance and construction activity, the applicant shall submit a site plan development permit for the project. Board of Adjustment approves the natural vegetation proposed instead of landscaping. An applicant must agree in writing to these conditions prior to commencement of site work.
Thank you. Any questions for staff on this project? Special use permit. Okay, thank you so much. Anyone here wishing to assert standing in this matter? Going twice, 3 times. The applicant's here with us. How are you today?
Good.
Good. Still good? Okay.
Still good.
All right. It's all yours.
I want to be respectful of everybody's time. We have submitted the application showing compliance with each of the elements of the ordinance. I'd be happy to go through those line by line if you would like, or I can just answer any questions you all might have.
All right, we'll open up for questions.
I have none.
And of course, we're seeing this in the first place because there is a special use permit required for these, of course, in the
Yes, sir.
ordinance. Yeah. Okay. Hearing no other issues, if you want to summarize, and we can move forward with a board deliberation.
Okay, that's good by us. We'll wait to hear what you have to say.
Wonderful, thank you. Well, yes, please.
Applicant, whether or not this is located within 5 linear miles of an aviation facility? That's
Yes.
one of the issues that has to be addressed by this board.
One final question for you. Is the proposed project within 5 linear miles of an
It
aviation?
is. Yes, it is. Yes, it's allowed to be. They just
Okay.
have to get approval from the,
From the FAA, which we
yes,
submitted.
which they
If
submit.
you'll come up and just point out, just summarize that letter for us and that issue for us.
Actually, as I get closer, I don't need those. Okay, so, yes, we've obtained from the FAA a determination of no hazard to air navigation letter, basically just stating that aeronautical study revealed that the structure would have no substantial adverse effect on the safe and efficient utilization of the navigable airspace by aircraft or on the operation of air navigation facilities. Therefore, pursuant to the authority delegated to me, it is hereby determined that the structure would not be a hazard to air navigation provided the following condition are met. Emissions from this site must be in compliance with the parameters set by collaboration between the FAA and telecommunications company and reflected in the FAA 5G C-band compatibility evaluation process, such as power, frequencies, and tilt angle. Operational use of this frequency band is not objectionable, provided the wireless providers obtain and adhere to the parameters established by the FAA 5G C-band compatibility evaluation process. Failure to comply with this condition will void this determination of no hazard. And that is standard procedure for us, and we will, if we haven't submitted a statement and we need to, we can certify that we will comply.
Okay. And can staff point us to the online documents on this case to see the name of that letter as we're looking at the case online? There's several letters included, but what's it called? Got a negative AM certificate, got the engineering fall zone letter, to make decommissioning letter. Thank you. Thank you. I just want to clarify that staff is working on that currently. Can staff take a look online at our list of documents for this case and let us know where this letter is? If it's uploaded.
Excuse me, Chair. So the material that was handed to you earlier, the new exhibit?
No, he's looking for the FAA.
FAA, yeah.
Okay, thank you.
Termination of no hazard to air navigation. I just want to make sure we have it already.
There's a decommissioning letter, an engineering fall zone letter, but I do not see an FAA.
Yeah. That's fine, as long as we have it here. We'll go ahead and formally admit this letter then from, regarding the FAA's determination of no hazard to air navigation. And you'll have a copy of that? Yeah, okay, thank you. Pass it this way. Okay, any questions on that or anything else about this matter? Special use permit. Hearing none. Anything else to summarize?
No, sir. Thank you all for your time.
Wonderful. Thank you so much. We'll close the public hearing and open for board discussions, deliberation, and a motion on this.
I'm sorry.
Nope, no, but we will start a second.
Yeah, go ahead,
Paul.
I see no reason not to grant this request.
It seems like this is a case that has an awful lot of people who have done an awful lot of work, producing an awful lot of reports from varying perspectives. And you guys have good practice, I'm sure, because you go through it every single time.
Yes, sir.
I don't see any concerns with it.
Agreed.
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 And this is a good area for it and need of coverage, and it's a high-growth area in the county.
And the
So,
topography's good.
Topography is good, location being shrouded naturally on the property from other or nearby roads. That's good, too. Motion on the special use permit.
Mr. Chair, based on the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the GEIS maps, the staff report, the testimony presented at the hearing, I move that this board adopt the following findings of fact. One, that this matter was properly advertised, is within the board's jurisdiction, and is ripe for its consideration. Two, that this application, together with its conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in the Buncombe County Code of Ordinances 78-621, subparagraph 3.
There's a motion on findings of fact. Is there a second? Second. Having a motion and a second, all those in favor, please raise your hand. Any opposed? That passes.
Mr. Chair, based upon the foregoing findings of fact and for the reasons set forth therein, I move that this requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
There's been an approval motion. Is there a second?
Second.
All those in favor, please raise your hand. Any opposed? That passes. Thank you very much. And we'll ask for a reading of an order.
Dispensing with the caption, this matter was properly noticed and advertised, is within the board's jurisdiction, and is ripe for its consideration. That the applicant applied for a special use permit pursuant to the zoning ordinance of Buncombe County to establish a telecommunications tower on lot PIN 9653-38-0860. The property is located in a conference center resort zoning district. At the hearing, the applicant and any parties withstanding were given the opportunity to offer oral and documentary evidence, as well as submit questions to each other, county staff, and board members. Pursuant to the Buncombe County Code of Ordinances, the board finds the following regarding the special use proposed in the application. With respect to the standard use permit standards, the structure shall be enclosed by a woven wire fence at least 8 feet high. The perimeter of the fence required in the subsection above shall be buffered by landscaping vegetation. Adequate landscaping shall be provided and meet standards provided in the Buncombe County zoning ordinance. Emergency contact information for the owner and manager of the facility shall be prominently posted at the site. A plan for decommissioning of the facility shall be provided and adequate. Facilities using wind as a means of electricity generation shall present an area map to scale depicting the proposed facility and the closest residential structures and the publicly maintained roads within the area. At locations where the facility will exist alongside other uses, the applicant shall include a description of the other uses which will occur on the site and how public safety will be guaranteed. The proposed development is located within 5 linear miles of any aviation facility. The proposed facility is not located within 1,320 feet of a North Carolina or U.S. highway or within the Blue Ridge Parkway overlay. The proposed facility is not located within the steep slope, high elevation, or protected ridge overlay districts. Adequate proof has been provided that the facility will not create electromagnetic interference with any radio communication or telecommunication system, aircraft navigation system, or radar system. Oops. The applicant shall register with other state and federal agencies as required. Proof of this registration must be provided to the Board of Adjustment. Pursuant to the Buncombe County zoning ordinance, satisfactory provision and arrangements have been made for at least the following as it relates to: the proposed use will not adversely affect the health or safety of persons residing or working in the neighborhoods of the proposed use. The proposed use will not be detrimental to public welfare or injurious to property or public improvements. The proposed use will not cause or have great adverse effects on surrounding properties due to noise, vibration, odor, or glare effects. Satisfactory ingress and egress for the proposed use of the property and proposed structures has been provided. Provision of off-street parking and loading areas where required, with particular attention to the Buncombe County zoning ordinance, have been arranged for. Provision of adequate and proper utilities, when required, have been arranged for. Provision of buffering, if deemed necessary, with reference to type, location, and dimensions, have been arranged for. Signs, if any, and proposed exterior lighting with reference to glare, traffic safety, economic effect, and compatibility are in harmony with properties in the district. 9 doesn't seem applicable. But playgrounds, open spaces, yards, landscaping, access ways, and pedestrian ways with reference to location, size, and suitability have been arranged for. Buildings and structures with reference to location and size and use are acceptable. Hours of operation with particular reference to protecting and maintaining the character of the neighborhood are acceptable. The following conditions are necessary to ensure that the proposed use will conform to the requirements and spirit of the Buncombe County zoning ordinance. The project must be constructed as depicted in the site plan. A telecommunications permit must be submitted and approved prior to submitting the site plan and submittal of the building permit. Prior to commencement of land disturbance and construction activity, the applicant shall submit a site plan development permit for the project. The Board of Adjustment approves the natural vegetation proposed instead of landscaping. The applicant must agree in writing to these conditions prior to the commencement of site work. Based on the foregoing findings of fact, the board makes the following conclusions of law. The applicant's request for a special use permit, together with the imposition of conditions found necessary above, which are incorporated herein as if fully set forth, meets each applicable requirement of the Buncombe County zoning ordinance. Now, therefore, based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment orders that the applicant is hereby granted a special use permit to establish a telecommunications tower on the property as requested, subject to the conditions referenced above, which are incorporated herein as if fully set forth. May 13th, 2026.
There's been an order presented to the board. Is there a motion on the order? There's a motion and a second on the order. All those in favor, please say yes. 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 Any opposed, no. Thank you. Change up on you there. Thank you very much. Congratulations.
Thank you all.
Any other matters from staff today?
I can let everything kind of quiet down if you'd like.
Sure, yeah. And we're going to continue with a little discussion here. If you'll take your conversations, excuse me, take your conversations outside, please. Thank you. Yeah, thank you.
So, speaking of the July meeting and then also cases, I know the board to discuss that. It has been discussed amongst staff that we may be entertaining the idea, if the board is available and up for it, to do a special meeting or a kind of double header meeting next June. We currently have 13 cases in the queue that need to be reviewed.
Ooh, that's new.
Yes.
That's new, yeah.
Yes. So we've been trying our best to, of course, make all of these meetings as robust as we can to get through these. But as you know, there have been a lot of continuances that have happened today. One of them were closed, but Carroll has also continued. So it is not set in stone, but I did want to give the board a heads up on that we will be sending an email out to see if you are available for that in order for us to get through this quite extensive backlog, especially if Carroll is going to be continued until July.
Is, just to dig in a little bit on that, is the idea right now that we will do our traditional 2-session, 9 a.m., 1 p.m., or 9 p.m., noon?
If
9
the
a.m.
board is available for that and is agreeable, that would be our preference, just to, we've done that before, kind of a double header. Again, this is just preliminary, but I did want to bring that to the board's attention as a possibility.
And we might ask board members who can stay the whole day to do that, but then they can volunteer for one or the other as well.
Yeah.
So, don't think you have to stay all day. Yeah.
I'm not here at all.
Okay. Okay. That's helpful to know. Yeah. This is
So this is
June, right?
Yes, and this is just, we don't need to have answers right now.
You're not excused though, Greg.
This is, we don't have to have answers right now, but it is just letting
Right.
the board members know, because we have such an extensive backlog, that we need to get through.
And of course, the impossible question is June enough to do that, to clear that backlog, which
Yes.
is not possible to really answer. So, and then we have July with the continuance of the Carroll case.
Yes. So.
Okay, let's take it 1 month at a time.
So
Yeah.
again, just letting you know that something may be coming down the pipeline.
That's perfect.
What is the double header plan again?
All that means is that we may have 2 meetings back to back in one day.
And what's the times? Is it?
It would be 9 to noon, 9 to noon, 1 to.
I think last time we had to push it to 1 to make it seem, to put an hour in between them.
Yeah,
So
but
like
we-
9 to
again, we
12
will
and
let you
1 to
know.
4, 1 to
Yeah.
4 maybe.
You'll- yeah.
And you could do either one or say, I only want to do afternoon or only want to do morning, Yeah.
So again, wanted to just prep the board on that, again, because Carol was brought up about July, and if that's happening, then we do definitely need to get through these cases.
In the staff's judgment, are these cases that are complex, incredibly complex?
we are going to work through those.
Okay, okay. Sounds good. Motion to adjourn? All right, second.
Thank you.
All right, we're adjourned. Thank you.